Hello, this is Court Watch with Alex Sawyer, and I'm excited to bring you the 6th episode of my podcast, where I will be joined by Josh Blackman, a professor at South Texas College of Law. We will be talking about the Supreme Court's arguments in late February over big tech and its potential legal liabilities, as well as how the justices acted during arguments over President Biden's plan to forgive roughly $400 billion in student debt. But before I chat with Josh, I had a chance to speak with Senator Eric Schmitt prior to the oral arguments over Biden's student loan forgiveness plans. He was Attorney General of Missouri before being elected to the Senate, and he's responsible for one of the legal challenges to the debt forgiveness agenda. Missouri and 5 other red states argued that the president does not have unilateral authority to issue such a sweeping debt forgiveness, and the move is unconstitutional. A lower court agreed with them, but the Biden administration appealed to the Supreme Court. The feds argue that the president has emergency powers under the HEROES Act, which was passed in 2003 to issue some debt forgiveness in the wake of September 11th to certain groups of people, particularly those in the military or impacted by war. Biden argues that the COVID-19 pandemic qualifies as an emergency, giving him the authority to forgive the debt, since, according to his Department of Education, quote, millions and millions of borrowers will be in default due to the financial hardships caused by the COVID-19 pandemic. The oral arguments were lengthy, and the justices also heard from a lawyer representing 2 borrowers who claim they would be left out of the forgiveness plans. They say that it's unfair and violates federal law. Here is a bit from my interview with Senator Schmitt.
Hey, Alex.
Hey, thank you so much for taking a few minutes to chat. I really appreciate it. I know you're on the go.
Sure. That's okay.
And we spoke back when you were the Attorney General in Missouri, and I appreciate now getting to chat with you in this respect. So I thought I'd ask you, I cover the Supreme Court, and given that you pretty much led the lawsuit along with, I think it was like 5 other red states against the Biden administration's plan to forgive all the student loan debt. If you could explain, I think I saw it was in the original complaint about how the argument is that this is beyond the president's power, that it's unconstitutional, but y'all made the point that it's also like unfair, right? The idea that Americans would have to pay for another person's debt. Can you explain what it would mean for Missourians, or I guess really for people in every state, if the Supreme Court were to side with the Biden administration here and the debt forgiveness program went forward? Would that mean like an increase in taxes? What kind of impact would it have?
Well, I mean, certainly you're dealing with spending issues and debt issues already, and there's just no way in God's green earth that the President of the United States or any person, one person, has the ability to wipe away $500 billion to $1 trillion worth of student loan debt when he's not authorized by any law to do that. And I think it was a cynical political ploy during election season. He has no authority to do this. And so that's the legal argument. The larger issue is just one of fairness. I mean, how is it fair that the people who chose not to take on debt or worked to pay off that debt or did something else entirely, right, to not have to pay for, the unpaid bills of the tenured professor with a theater degree? I mean, the truck driver and the waitress shouldn't have to do that. And so I think it's just it's really unfair to hardworking Americans across the country that they would be saddled with more of this debt. And, the legal issue, of course, is the Biden administration just doesn't have any authority to do it in the first place.
Mm-hmm. Now, let me ask you a quick, I guess, maybe procedural question. I always notice the Supreme Court takes cases that usually they think that there was like an error with the lower courts or their conflicting circuits. I think both circuits here halted the program, right? So, should we read anything into that? Or is it just this is a big
I don't
deal?
think so. I think it's just a big issue, and the court will often take cases that are, it's an open question, has real significance, obviously, the dollars and, all the issues that we talked about. And I think one of the reasons why it was important for Missouri to take the lead here, we had standing, which is kind of an issue that was early on. People were figuring out, hey, who would actually have standing to bring this challenge? Well, Missouri has a loan servicing entity called Mohila that services student loan debt, and they've obviously, with the forgiveness, that they would not be doing as much of that anymore. So that gives Missouri standing. The other states have made other arguments. In our case, I think the 4 or 5 other states that are on that lawsuit. And I just think the court's taking this because it's a big issue. Mm-hmm. And like I said, I'm very hopeful that they'll affirm the lower court's holdings.
And you mentioned the notion that how it's unfair. One of the cases that will be heard alongside yours is 2 borrowers who have basically sued saying, hey, we should be part of this program too, but we don't qualify. And my question is, would if for some reason the lower courts weren't affirmed, would this like open, I guess, the floodgates for litigation from student loan borrowers that can try to petition courts across the country to try to become part of this program or find a legal argument to say, hey, what about me?
Yeah, I mean, I think that opens that up certainly. And you've got the argument then too of let's say somebody paid off their student loan debt like a week before, the Biden administration chose to do this. I mean, how is it fair to that person who, was trying to, fulfill their obligations?
Right.
So I think all of it just opens up. Again, it's not legal. I think it's unfair as a policy matter. And I think most Americans recognize that. And I think that, Missouri and the other states are right on the law, and I think that carries today.
I'm joined now by Josh Blackman, who I'll ask to first comment on the student loan case. I played my clip with Senator Schmitt and his argument as to why the justices should rule against the president. I wanted to ask you, Josh, what you thought about the oral arguments and basically if you have any prediction on how the court could come down. There was very interesting repeated questions on standing, whether or not, the states could even bring the suit. For example, it was interesting to me that Justice Barrett seemed to echo concerns on that with the liberal wing of the court. What did you pick up on?
Sure. Thanks, Al. Good to always talk with you. In any court of law, there are often two questions. One, right? The first question is the so-called merits, right? Who's right on the law? Are the plaintiffs correct that the student loan policy is illegal? Or is the government correct that this policy is legal? Right? That's sort of the first question that we all care about. Mm-hmm. But there's a question that comes before it that's more important. Can the federal court even decide the case, right? In other words, not every question can go to court. You can only go to court if you're injured by some government policy. This is what's known as standing. Do you have standing or the power to bring the suit? And a lot of the discussion in the case was, on the one side, can Biden do this? And on the other side, is there standing for the state of Missouri and some private plaintiffs to bring this case? So even if Biden is acting unlawfully through this policy, if the courts can't hear the case, there's no standing, then, it's like the perfect crime. You get to steal $400 billion and no one can stop you.
Right. And that's why it's such a big deal. I guess, what did you make of, so the claim with Missouri is that they have, I guess it's called MOHELA, and it's basically a loan servicer. I believe it touches loans in all 50 states. So they're saying that entity, I guess the state created it, but of course, according to the liberal wing of the court, they emphasize that the state isn't responsible for any of its legal liabilities. Basically, it's an independent corporation, and it should be there suing on behalf of itself. But that's kind of what did you make of that? There didn't seem to be interest explored from the Chief Justice on that. He was more interested in the merits, as you referenced. So, and sometimes I like to pay attention to what he asks because he seems to be the middle of the court, or used to be, so to say.
Right. I mean, it's prudent to keep your eye on the chief because he's often always in the middle of the court, and Justice Kavanaugh seems to do what the chief does in most cases. So you talk about this MOHELA, which is this Missouri Higher Education Loan Authority, which is this sort of entity that processes loans in Missouri. The exact relationship between the state of Missouri and this MOHELA is a little bit complicated, and I'm not sure it's even worth explaining. On one side, the government argues that MOHELA is this independent entity. They can bring their own lawsuit, and if they brought this lawsuit, they could win the case. Missouri argues, no, the state can sue on behalf of this organization, and the state can make a different claim. The state expects certain money that might be paid from MOHELA, and these loans are canceled, they might get less money, right? So that's the state's injury.
Right.
But if that argument doesn't work, then Missouri has no basis to bring the suit, and then the case might be dismissed altogether.
Mm-hmm. I guess, since we didn't hear from the chief on this one, and like I said, I mentioned he's in the middle of court, and you mentioned Kavanaugh. Kagan, too, but she was very into standing. I don't know. Should we read into that, I guess?
I think the chief really wants to rule against Biden here, and he's going to find a way. He's not very big on rules and details and the like.
Yeah, I gathered that too.
He referenced the DACA case from a couple of years ago. Said, "Well, we ruled against Trump. Now
exactly.
It's against Biden."
Yeah.
I mean, in Roberts' mind, it's also sort of weird balancing game. Where if he rules against Republicans enough, he can rule against Democrats once in a while.
Right.
It's a bizarre Hunger Game approach to the Supreme Court. Only the strong will survive. But I don't think he'll care. He'll find standing one way or the other. Barrett, though, she's a former law professor. She's a bit of a stickler for standing. She's very particular with what she requires. And I get to hear voting with the court's liberals say that there's no standing here. This case goes away.
It did sound like that. And I will say, you mentioned Kavanaugh being in the middle of the court. He did. He had a good quote, I think it was, suggesting he's wanting to look at the merits and rule against Biden as well, because he mentioned, I think, some of the court's greatest moments were when they checked, government overreach or power or executive power.
Right. Kavanaugh often takes a sort of historical approach. He mentioned the famous steel seizure cases where President Truman tried to seize steel mills during the height of the Korean conflict. If Kavanaugh sees this as this, violation of the separation of powers, he'll look past standing also. I think he can find a way to either let the state sneak through here or maybe the private plaintiffs. I don't really know which one works. But if one of the plaintiffs has standing, then they all have standing.
Mm-hmm. Yeah. It's interesting. The arguments were very lengthy. It was one of those, it seems like this new format is just we're going on and on for hours. Like I'll go in there and think, okay, I'm going to be in the courtroom from 10 to 12 and it's like 2 o'clock and 3 o'clock getting out. Yeah,
no more.
It's pretty wild.
Did they even take a break between the arguments? I know it's about a 5-minute gap maybe.
It was just a 5-minute gap. Yeah. And at that point, for me with press, like you're pretty much stuck in there. You can't, it's hard to get in and out. Like they don't let you.
You can't go to the bathroom.
Right. Yeah. And like also you have to go through security, right? All of that. And so it's interesting. And also for press, like we don't do electronics in the courtroom. So it feels almost like how many hours of arguments have been going on since we, mentioned to like the readers or an audience that we're going to be hearing the case. It's like, are they still wondering what's going on? Like, are they still in there? Like it feels like you have to run out and give like some sort of update, a play-by-play.
Exactly. Exactly.
But I guess we'll switch gears and we'll talk about prior to hearing the student loan argument, the week before, the justices heard 2 cases relating to big tech. And so if I'm trying to explain this and it becomes kind of confusing, jump in here, Josh. But basically, one case was against Google, the first one that was argued, and it was brought by a family who lost a loved one in a terrorist attack. And they claim Google, because of how it uses its algorithms, promoted ISIS content that led to the attack that killed their relative. They've challenged Section 230 of the Communications Decency Act, passed back in the 90s. It's been basically like a legal shield for tech companies. They say they aren't liable for what third parties post on their platforms. Now, the second case, it was against Twitter and the tech companies, also brought by a family of a terrorist attack. And they've sued under a different federal law. And I think it's the Anti-Terrorism Act was cited and some documents I saw. And it seemed to me that during both cases, there was so much overlap in the questions. I don't know how the court will separate the 2 cases because the term aiding and abetting came up during both arguments. And I think it was maybe Justice Sotomayor and Justice Jackson kind of like definitely asked questions related to both cases during both days, even though the laws at issue are different. I got the gist and the feeling that the court wasn't necessarily ready to chip away at Section 230, but they might find some sort of liability under a federal terrorism statute. Like, what did you leave thinking? What was your impression?
I think they regret taking the case. This is a very complicated case that they don't need to decide. There's not really even a circuit split on this issue. It's entirely possible to get rid of it. So let me just take a step back. I think your description was quite good, Alex. You don't underestimate yourself. I think you got all the high points. Section 230 is this law passed from the 1990s that gives certain immunity from suit to internet service providers who moderate content, right? The extent of this law is very complicated because the internet today looks extremely different than it did almost 30 years ago. And I think the justices are nervous about upsetting the apple cart. On the flip side, though, the lower courts have read Section 230 quite broadly, and many conservatives are unhappy with this because it gives basically Google and YouTube and Twitter this sort of blank check to do whatever they want and take down content. So I know the conservatives are like, well, look, you leave up all this ISIS content, but you take down conservative videos, right? How is that fair? So this is a hard case. Also, the sort of personal component. These are people who had their family members killed in terrorist attacks. It's actually very, very tragic. and they're trying to take some remedy from someone who helped promote the videos that radicalized these terrorists. So you sort of feel for the parents in this case who lost a loved one.
Mm-hmm.
Justice Kagan perhaps said it best. She said, "We're not the 9 most expert people on this area." So it's very problematic.
Right. She was referencing that they're not experts on the internet, and it was kind of evident during some of the arguments too that even like it's a complex case, complex issues, and sometimes the arguments it felt like do they, with either the questions or even what the lawyers were saying, do they understand how it works, like the algorithms and all of that? It was confusing, but I did feel like I don't know how they're going to be able to rule against the tech companies maybe on one ground and not the other, because that's kind of how I felt like they were leaning to do so. But I guess that's one of those things we'll have to wait and see. Did you think that there's a way that they could get rid of the case without having to dive into this?
They can just dismiss the case and providently granted. I mean, literally get rid of it.
Yeah.
Just dismiss it and not decide it.
Do you think they will?
And I don't think anyone would.
Or do you think there's too much attention at this?
They're gonna try and give it a go, and it might just come down to the end of June. They're really busy, and they just either maybe dismiss the case altogether and just say we don't have to deal with it now.
Yeah, it was definitely an interesting 2 days to sit in the courtroom on that one. Now I hate saying this whenever I look at dockets, because I always say, oh, like there's not very many interesting cases coming up, later this month. But of course, they're interesting to the advocates and to the parties at issue in the different disputes. But basically, for March, I don't see these high profile cases coming up later this month. But there is one in April. Tell me if I'm missing anything in March. Am I?
No, there's one fun case about Jack Daniel chew toys, where someone made a chew toy that looks like a bottle of Jack Daniels. And whether that's a violation of the copyright, and that's kind of fun, but
it is fun. I don't know exactly, unless you have one of the chew toys. Are interested in copyright law. I'm not sure how that touches your house, but there is an interesting case, April, that was recently granted. It has to deal with a post office worker who says due to his religious beliefs, he can't work on Sundays. The post office, I guess he kind of went between 2 post offices in Pennsylvania. They're small. They're saying they can no longer substitute his Sunday shifts. And I guess they have Sunday obligations due to contracts with Amazon and deliveries. So his case is now coming before the court. It'll be argued April 18th, I believe. And his name is Gerald Groff. I'm actually going to get the opportunity to chat with him later this month, and I'll have his interview. Yeah, so I'll be able to share parts of what he was saying before the justices take and hear from his lawyers. But given that there's been a lot of talk about this Supreme Court, the makeup of it being very pro-religious liberty, the lower courts had ruled against the employee. And I'm curious, do you think, like, every time a case is granted, I wonder, like, why do you think it was granted? Do you think the lower court got it wrong? Does Mr. Groff have a good chance of success here?
Well, we have a precedent from the 1970s called TWA versus Hardison, right? This case made it very easy for employers to basically disregard the religious objections. If a religious objection, like, for example, I can't work on Saturday because of my religion, right? If religious objection caused even the smallest burden to the employer, they can say, sorry, we can't accommodate you, right?
Mm-hmm.
This opinion was probably wrong 50 years ago, but the precedent stood for half a century. Now, I think the conservatives will reverse that precedent, and they will say, the statute means what it says, and you have an obligation to accommodate people of faith. So this shouldn't be a hard case. It should be a 9-0 case, but unfortunately, religious liberty has become so contentious in recent years, this will not be a 9-0 case.
Do you think it'll be one of those 6-3 ones? I mean, it's interesting because you have even, like, I think of Justice Jackson when she was confirmed or was doing her speech after she was nominated. She talked about her religion or her faith in God. It's just interesting, like, I know they'll separate their own personal views from the law, but you do have religious members on the other side. I think the reason
why is that this is an easy case that involves, a person who worships the Sabbath on a different day, right? That's an easy case. But there can be other employees who have more vigorous objections that involve gay rights and the like, who refuse to do certain tasks. And I think the left is worried that if they open up the door here, social conservatives will have the benefit, and then that won't be good. So I think the liberal justices, Kagan and others, will try to narrow the scope of this opinion as much as they can.
Mm-hmm. What other cases have I haven't, those are kind of, we've touched on the big arguments from this last sitting. And then of course the major one in April. I don't know, is there any other ones that I've missed? Anything you're tracking?
No, the only other action that might happen involves Moore v. Harper. This is the election case in North Carolina, the so-called independent state legislature doctrine case. Recently, the North Carolina Supreme Court switched majorities. A Republican majority was elected into office. And the court said they're going to reconsider the decision from the Democratic appointed court. And so it's very likely the court nullifies the prior decision, which would remove the Supreme Court case from the docket. So the Supreme Court may not even decide the huge, big, controversial independent state legislature case. It may just fall off the docket altogether.
Wow, yeah. I mean, so they could get rid of the social media case. They could get rid of that one. What are we left with? Affirmative action?
Yep. I mean, really, the docket may be very lonely by the end of the term.
Yeah, it'll be interesting. Also, I don't think they took as many cases this year as they have in the past, right? Or am I wrong on that?
No, I mean, in recent years, the number of grants has gone down, and cases keep falling off the docket that either settle or go away.
Yeah. Well, I appreciate you taking time out of your schedule in between classes to chat with me. It'll be interesting to see if any of our predictions end up, coming to fruition in June when the court will likely issue these rulings. This is one of those things I'm like, are they going to go into July? But I guess not. If you think, like we just talked about.
We'll see. Yeah. They always run to overtime, it seems, in recent years.
Yeah. So, all of us are trying to plan our vacations, but can't do so until the court wraps up. But any grants you're watching, by the way? Anything pending?
The big one is the net choice case. This is about Texas and Florida have these laws that sort of restrict social media companies. The court asked for the views of the government, of the Solicitor General. So that kicks into another couple months. But by June or July, we may get a grant to the net choice case, which is a much bigger deal about whether the states can sort of restrict big tech. Yeah.
So on that point, would how they come down possibly if they don't get rid of the social media cases here impact that?
Yeah. In other words, don't get rid of these cases and wait till the big one next year and decide it when you have to.
Interesting. Okay. Well, we'll have to follow that. Thanks so much for your time, Josh. I really appreciate it. Thanks for tuning in to the 6th episode of Court Watch. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.